South Africa rewrote its nationality law since the end of apartheid in 1994 and the establishment of majority rule in the country under the African National Congress. The 1995 South African Citizenship Act did away with the previous Apartheid-era 1949 and 1970 acts which had established separate bantustan citizenship to the country's African majority and inferior levels of citizenship to the country's Asian and colored minorities. Citizenship by birth. According to Chapter 2 of the 1995 law, anyone who was considered to be a citizen by birth prior to the enactment of the law, who was born in the Republic on or after the enactment of the law, is a citizen by birth. Also, a person is a citizen by birth if they can be considered a citizen by descent and at the time of birth at least one parent was 1. in the service of the government, 2. was employed by a person or group located in the Republic, or 3. was in the service of an international organization in which South Africa had membership. There is an exception to the birthright citizenship provision. Those born to visiting foreign diplomats or their employees, or non-resident aliens are not considered to be citizens by birth. Citizenship by descent. Under the 1995 law, a person born outside South Africa to a South African parent is a South African citizen by descent upon registration of the birth under South African law. Naturalization. Citizenship can be acquired through naturalization if the following conditions are met. The valid residence permit is a certificate of exemption. 1 year of ordinary residence in South Africa prior to the application for naturalization. 4 years of physical residence in South Africa during the 8 years before the application for naturalization, excluding the year of ordinary residence. In the case of an applicant for naturalization being married in a spousal relationship with a South African citizen, 2 years of permanent residence and 2 years of marriage spousal relationship to the South African citizen's spouse prior to the application. Be of good and sound character. Be able to communicate in any one of South Africa's official languages satisfactorily. Have adequate knowledge of the duties and responsibilities of a South African citizen. Naturalization of an adult also confers South African citizenship upon that adult's minor children. Loss of citizenship by naturalized South Africans. Naturalized South Africans who left South Africa before the 6th of October 1988 and did not obtain a letter of exemption from the South African authorities may have lost South African citizenship after 7 years' absence. Visa-free travel. Visa requirements for South African citizens are administrative entry restrictions by the authorities of other states placed on citizens of South Africa. In 2014, South African citizens had visa-free or visa-on-arrival access to 97 countries and territories, ranking the South African passport 41st in the world according to the Visa Restrictions Index. Dual nationality. Prior to 2004, South Africa in principle did not recognize the multiple citizenship of its nationals unless the citizen applied for an exemption or permission letter under a 1995 law permitting South African citizens to travel using foreign passports. Since 2004, South African dual nationals may travel without hindrance as long as they enter and leave South Africa on the South African passports. Dual nationals may petition for temporary, emergency or permanent South African passports for this purpose. However, a South African citizen who by formal and voluntary act acquires the citizenship of another country, automatically loses his or her South African citizenship unless they apply for, and receive permission to retain the South African citizenship before acquiring the citizenship of another country. A naturalized citizen, however, cannot apply for such a retention. South African citizens under the age of 18 years are exempt and do not require permission as long as they acquire the foreign citizenship before their 18th birthday. They automatically retain the South African citizenship for life unless, once they have reached the age of 18 and they then wish to acquire a further foreign citizenship, they will then have to apply for prior permission to retain the South African citizenship. Failing to do so, they will automatically lose the South African citizenship. Many South Africans have claims for another citizenship. British nationality. Prior to the 1st of January 1949, South Africans were British subjects under United Kingdom law, which also applied in South Africa. See British nationality law. Between the 1st of January 1949 and the 1st of September 1949, South Africans remained British subjects without citizenship unless they had already acquired citizenship of the UK and AMP colonies or another Commonwealth country. Citizenship of the UK and its colonies. On the 2nd of September 1949, most British subjects from South Africa acquired South African citizenship. Those who did not become South African generally became citizens of the UK and AMP colonies, provided that they had no connections with any other Commonwealth country or island. Such persons would only have acquired British citizenship in 1983 if they had acquired a right of abode in the UK at the time. Otherwise they would have become British overseas citizens. Those of an ethnic Indian or Pakistani background who were British subjects before 1949, but did not acquire South African citizenship in 1949, may have remained British subjects without citizenship. See Indian nationality law. British overseas citizens and British subjects who have no other nationality, and have not lost or renounced another nationality since the 4th of July 2002, may register as British citizens under S4B of the British Nationality Act 1981 without requiring UK residence. This facility has been available since the 30th of April 2003. Those who have immigrated to the UK may have additional options for acquiring British citizenship. Between 1949 and 1961, all South African citizens remained British subjects by virtue of the South African citizenship. This was ended in 1961 when South Africa left the Commonwealth. By the time South Africa returned to the Commonwealth in 1994, the phrase British subject had been replaced by Commonwealth citizen, right of abode in the United Kingdom. As South Africa was a foreign country between the 1st of January 1973, the date the Immigration Act 1971 came into force in the UK, and the 1st of January 1983, South Africans cannot have right of abode in the UK unless they also hold citizenship of another Commonwealth country or of the UK itself. This particularly affects South Africans born before 1983 with a UK-born mother, who would otherwise usually have had the right of abode in the UK. However, the changes to British nationality law on the 30th of April 2003 have allowed those born in South Africa between the 8th of February 1961 and the 31st of December 1982 to a UK-born and naturalised mother to apply for registration as a British citizen by descent. With this comes a right of abode in the UK. This concession is not specific to South African citizens. Commonwealth citizenship. Following South Africa's return to the Commonwealth in 1994, South Africans are treated as Commonwealth citizens in the United Kingdom. This includes the following benefits: eligibility for the UK Working Holiday Visa Scheme. Eligibility for the UK ancestry visa. The right, if resident in the UK, to vote and hold public office in the UK. There are no specific concessions in terms of eligibility for British citizenship, and South Africans must meet the same rules for registration and naturalisation as citizens of any other country.